So is our IT department ready to go?
Yes.
Okay. That might be a good thing.
Notary Dallas Lee is going to swear people in. I will call the cases.
So we're ready to go?
Yes, sir.
Okay, I call this meeting to order. My name is Norm Fugit. I am the special magistrate for the city of Newberry. The purpose of this gathering today is to hold hearings on various cases that are brought before the special magistrate. Before we get started, it is 1:02 p.m. and before we get started, let's begin with the Pledge of Allegiance. So if everybody would stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay, the next item on the agenda is remarks of the special magistrate, and under that, approval of minutes from the last meeting, and I'll just get with the clerk on that part of it. Okay. So let's move. Then the next item on the agenda is remarks of staff and attorneys. Do we have any remarks?
Your Honor, just as some housekeeping information, we have provided some information with regard to announcements to the citizens, what happens after the first hearing, and also with regard to what a non-compliance hearing is, because this is the first one that we'll have in our new process.
Okay, so what I intend to do with that is when we begin in the particular case that is on the non-compliance hearing, I'll explain what the purpose of that hearing is, and the statement regarding what happens after the first hearing and the possibility of a second hearing. I intend to do that at each case as I do that.
Thank you.
So, any other remarks from
No.
staff or attorney?
None from staff.
Then, Madam Clerk, if you'll call our first case.
The first case is case number CE 2018-003, violation number 2018-02015. City of Newberry, Florida versus Robert Stout.
Okay, before I hand it over to you, Mr. Wolf, let me say that this is a non-compliance hearing. This case has been before the magistrate before. I found a violation, entered an order, and set a date by which the violation needed to be cured. Apparently, that has not happened, so it's coming back for a compliance hearing. The only thing that I'm going to do in the non-compliance hearing is determine if the respondent brought himself into compliance or not. The city and the respondent will have an opportunity to speak and present evidence, present whatever they have to demonstrate compliance or non-compliance. The other thing that I will do, and because I reserve jurisdiction to do this in the initial order, I'll make a decision regarding the placement of a lien on the property based on any fines. I also reserved jurisdiction there too, so I'll hear from the city as far as any recommendation. I reserved jurisdiction to possibly recommend to the city commission that they engage to remedy the violation. So we can go there if we need to. With that, I will turn it over to our code enforcement officer to make the city's presentation on this case.
Yeah. If you would read the case.
Okay, and Ms. Johnson, when do we swear you in? Right now?
That's fine.
Yeah. I'm sorry, let's go ahead with swearing in the city staff that may give testimony today.
Please state your name for the record.
Richard Wolf.
You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Yours is fine.
Okay, the violation. So the location of the violation is 25613 Northwest 5th Avenue, Newberry, Florida 32669. That is in Section 4, Township 10 South, Range 17 East. Parcel number is 02371-003-000. The date of the first special magistrate hearing was June 4th, 2018, and the violation is he was found in violation of Section 14334 of the City of Newberry Code of Ordinances, which prohibits the existence of a dangerous building, or a fine and the amount of $50 per day will be assessed until compliance, plus $120 for prosecution costs.
Your Honor, my name is Rick Wolf, and I'm the code enforcement officer with the City of Newberry, and my credentials are on file with the clerk. In case CE 2018-003, the City of Newberry versus Robert Stout, the special magistrate has held a public hearing on June 4th, 2018, and it has issued a finding of fact, conclusion of law, and order. Pursuant to the said order, the respondent was to have taken corrective action on or before July 13th, 2018, which was 31 days from the date of the order being signed. A reinspection of the property located at 25613 Northwest 5th Avenue in Newberry, Florida, was performed on July 11th, 2018, July 31st, 2018, September 18th, 2018, September 25th, 2018, and yesterday, October 16th, 2018. And these re-inspections reveal that corrective action has not been taken for the City of Newberry Code of Ordinances, Chapter 14, Article 3, Section 307, relating to dangerous buildings and hazardous lands. This case was regarding a burnout mobile home that was abandoned and uninhabitable. I'd like to now show you some photographs of this case on those inspection dates. As you recall, back on February 20th, this was a mobile home that was partially destroyed by a fire and was sitting there in a dilapidated, unkept condition. The respondent did attend the first hearing and testified that he could conduct the cleanup within 30 days. Unfortunately, after the hearing, he was there one or two times and then is nowhere to be found. We've called and left several messages on his voicemail and have not been able to contact him. This is my visit on July 31st, which was after the correction deadline of July 13th. And there are several appliances, sink, tub, stove, still on the property. The floor and foundation for the mobile home has yet to be removed. On September 18th, I posted the property, leaving a notice of noncompliance hearing, an affidavit of noncompliance, and a statement, of why the hearing was taking place. and it was posted on September 18th as well as being posted at City Hall. On September 18th, again at the property, you can see the appliances and the floor of the mobile home still existing. September 25th, I again visited the property. The notice was still there that was posted, and the cleanup had not taken place. And this was yesterday. The weeds are getting higher, all the appliances are still there, and the structure has not been removed. That's still hazardous at the location. These photographs that are presented accurately represent the violation as seen and were taken on the dates so specified. Staff is recommending that a lien be imposed in the amount of $50 per day beginning July 13th, 2018, plus the prosecution costs in the amount of $120 as was previously ordered by the special magistrate. That fine as a lien shall continue until compliance is achieved. The total amount as of today, October 17th, would be for 98 days at $50 per day, would be $4,900 plus the $120 prosecution costs, totaling as of today $5,020. So that is staff's recommendation, that you find them in non-compliance and authorize the City of Newberry to file a lien against the respondent and any additional responsible parties. That concludes staff's comments.
It's the $120 that is not in addition to, that's just one $120 cost?
That's correct.
Okay. It looked like there was some progress made, if I'm just glancing at the photographs, there was some progress made on the cleanup in the first 30 days or so.
Well, prior to the hearing, there was some progress made where we found the respondent on the site, and they were doing some cleanup, and he said he was looking for an urn of one of his relatives' ashes that was in the structure. Since the hearing, very little progress.
So, okay. Is he required to get some kind of a demo permit from the city to progress with this?
In this case, where it was a burnout structure, there's no utilities that we would feel that were still needing to be disconnected, so we would not require a permit.
Okay. And I don't know that you directly said it, but I'm assuming you've had no contact with the owner since the last hearing?
The only contact, we posted the property because we didn't initially get a response back from the certified mail that we sent.
Right.
And then as you can see, there is a copy of a notice that was signed but is somewhat illegible. We can't read what the name is. But it did come back.
Okay.
It did come back signed, but we just for clarity's sake, we wanted to make sure we had adequate notice proof of service.
You've had no verbal contact with the owner since the last hearing?
I've attempted to call four times and left voicemails, but have not had any return contact.
Do we have any idea if there might be a mortgage or lien on this property by a third party?
No, I do not.
Okay. And I just say that because I'd like to think this is the point in time that if this ends up being impose a fine and end up being a lien on the property, we probably want to try to notice anybody else that might have an interest in like a lien or a mortgage on the property. So, okay, so thank you. Is Robert Stout present today? Anybody on behalf of Robert Stout? No. Okay. Okay, then I'm going to I'm going to find that the property has not been brought into compliance, and I'm referring back to my order of dated June 11th of 2018, in which I indicated that if the violations were not cured, then a fine in the amount of $50 per day would begin to accrue on the 31st day. So I am going to enter an order imposing the fine that I laid out in the original order. That fine as of today will be $4,900. I'm also going to impose the $120 for the cost of administering the code violation case. That was also mentioned in the original order. I'm going to add that to the $4,900, and so that will make a total of $5,020 today. And my order will also state that the $50 per day will continue to be added to the case, to be added to the fine and the lien until paid. In the prior order, I reserved jurisdiction to possibly recommend that the governing body of the city undertake remedial work to cure the violation. Does the city have any thoughts on that today?
Your Honor, we would like to continue to monitor the property and see if any corrective action is taken, and if at such time we feel that it's not a possibility, come back to you and ask for you to make that recommendation.
Okay. Very good. Anything else on this case? Okay. All right, then let's move to the next case. Madam Clerk.
Case number 2 is actually case number CE 2018-008, violation number 2018-08004, City of Newberry, Florida versus Karen Trail Cutler.
Okay, Mr. Wolf.
Your Honor, before we go on, I would like to, on the last case, to give a copy to the clerk of the photographs that were shown.
All right. So the clerk will enter those photographs and information into evidence for the prior case. Thank you.
Again, my name is Rick Wolf, and I'm the Code Enforcement Officer with the City of Newberry, and my credentials are on file with the clerk. In CEB case 2018-008, the respondent is Karen Trail Cutler. The photographs that will be presented are into evidence are accurately representing the violation as seen and were taken on the dates indicated on the photographs. On the 8th of August, the City of Newberry received an anonymous complaint of an overgrown vacant lot and excessive growth of vegetation, creating a hazard located at 26811 Northwest 3rd Avenue on tax parcel 02509-010-009. The property was first inspected by myself on August 14th, 2018, and was found to be within the incorporated city limits of the City of Newberry and to be in violation of the City of Newberry Code of Ordinances. The following ordinances being Chapter 14, Article 6, Section 14.331 through 341. Section 14.334 is dealing with creating, keeping, maintaining, or allowing the existence of a dangerous or building or hazardous land and is unlawful. It shall be unlawful for any owner of real property within the city to create, keep, maintain, or allow existence of dangerous buildings or hazardous lands as defined in the article or in such real property. This particular property had excessive growth of vegetation as defined as vegetation over 12 inches high that may be reasonably become infested by pests or create a fire or safety hazard. In addition, we also found a violation of Chapter 94, Article 5, Section 94-124. Section 94-124 deals with wrecked or non-operating vehicles on private property. No person in charge or control of any property within the city, whether an owner, tenant, occupant, leasee, or otherwise, shall allow any partially dismantled or non-operating, wrecked, junked, or discarded vehicle to remain on such property longer than 72 hours. And no person shall leave any such vehicle on any portion of the property within the city for longer than 72 hours, except as this article apply with regard to a vehicle in an enclosed building, a vehicle on the premises of a business enterprise operated in a lawful place and manner when necessary to operate such business, or a vehicle in an appropriate storage place. So essentially this was an unlicensed or inoperable vehicle parked in the driveway. The property in question is zoned single family RSF3 and is approximately 0.26 acres in size. Although the property shows to be homesteaded on the property appraiser's records, for the last few months there has been no one occupying the residence. The notice of violation 2018-08004 was mailed by certified mail on August 21st to the owner of record as recorded in the tax collector's office and to any additional responsible parties as the code allows, and was returned unclaimed. The notice of violation was also emailed to the respondent, Karen Trail Cutler, on August 21st, 2018. Legal service of the notice of violation and the notice of hearings was achieved on September 18th, 2018 by posting the property and City Hall of Newberry. In the notice of violation, the respondent was given until September 25th to correct the violation, completing one or more of the following actions. Clean up and remove excessive vegetation from property over 12 inches high and retain shrubs, trees, and bushes utilized as natural landscaping. Remove inoperable or unlicensed vehicle from the property or place in such enclosed building. Here are the photographs that I've taken on the occasions I visited the property. This shows the front of the property, and you can literally not see the home from the street. It's overgrown. Vines are up into the trees over top of the roof. There are fallen trees on the roof, and across the weatherhead where power enters the house. This was the first observation. In the driveway, there was a vehicle that was full of mold. The license plate had expired, and it was had a flat tire. Was definitely in inoperable condition. Here's a closer view. I want to point out that at no time have I entered the property other than being on the right-of-way or adjacent property of a neighbor with their permission. Looking in the other direction toward the east, here's the overgrowth of the property. You can't tell that there's an existing fence even there, and the vines just go from the ground level up through the trees. The adjacent property to the east, I contacted them, and they said that they haven't seen anyone at the house for several months, and I began to be worried because there was property on the house that there may have been an issue with someone still in the home or injured, or so that's why I attempted to contact the property owner of record through billing records of the city, and that's how I got in touch with Ms. Cutler, and then she had subsequently sent me an email saying, well, if it was an anonymous complaint, then she didn't consider it valid and that she was not going to respond. Now, I would like to submit both copies of the photos that I've taken and a copy of her email for the record.
Okay. I would like to see that email.
So this was the initial visit on August the 14th. And again, you can see the vines growing across the roof of the house. Visited the property again on August the 28th, and the vehicle had been removed. So basically, for the inoperable vehicle violation, she's was in violation, but is now in compliance. On September the 18th, after the notice came back unclaimed, I posted the property for the notice of hearing, the notice of violation, and the statement and a violation request for hearing. It was also posted at the bulletin board in City Hall. This is again visiting the property on September 25th. A few branches had been trimmed down. Not a significant amount of material had been cut down or maintained. I found a posted no trespassing sign on my posted notice when I returned on September 25th. And again, I want to reiterate that I had never went on the property. This is another photograph on the 25th of September. You can see the vegetation is just overgrown to the point of it being overwhelming. From the side yard of the adjacent property owner, one of the large branches of an oak tree has now fallen and is leaning against the weatherhead where power is supplied to the house. Again, you can see the amount of debris on the roof, which would clearly be a fire hazard. Yesterday, I revisited the property. There has been a little more vegetation trimmed, a small pile of vegetation in the front right-of-way, but nowhere near the amount of work that needs to be done to correct this violation. Again, cleanup and removal of the excessive vegetation of the property over 12 inches and retaining the shrubs and trees that were natural landscaping was our recommended action, and to remove the inoperable or unlicensed vehicle or place it in an enclosed building. As a result of my inspections, and particularly the inspection on October 16th, 2018, we recommend that you find the respondent, Karen Trail Cutler, in violation of Chapter 14, Article 6, regarding hazardous lands and dangerous structures, for creating, maintaining, and allowing the existence of a dangerous building or hazardous land, and for excessive growth of vegetation as defined as vegetation over 12 inches high that may unreasonably become infested and pests created or a fire hazard. We wish that you find Ms. Cutler in violation but now in compliance for the wrecked or inoperating vehicle under Chapter 94, Article 5. The unlicensed or inoperable vehicle that was in the driveway was removed on August 28, 2018. We ask that you give the respondent 30 days to comply as set forth in the corrective action stated in the original notice of violation, or to pay a fine of $50 per day until compliance is achieved, and to further that the city recover the cost of prosecution of $120. That concludes staff's comments.
The notice of hearing that's in the packet for a notice notifying of today's hearing, what date was that sent out?
I believe it was September 18th.
Would that have been the same date as the statement of violation and request for hearing?
Yes, and in fact, there should be an affidavit of posting in your packet.
Okay,
Notarized affidavit that confirms that.
got it. Did we attempt to deliver the notice of hearing by any other means?
Yes, we did, and it came back unclaimed. There's I think, right after the affidavit of posting is a green
Right.
card and unclaimed envelope that was returned from the post office.
The date on it's a little bit earlier. Did we had their email by then? Did you give her any try to give her any notice by email?
Yes, I did send a copy of the notice of violation by email.
And the notice of the hearing also?
I'm not sure that
Okay.
I did that.
Yeah, I'm not saying you needed to,
Yeah.
I'm just curious. Okay. Ms. Cutler, is Ms. Cutler here, or is anybody on her behalf? Okay. Okay, well, I think I've received sufficient evidence to find a violation of the hazardous lands ordinance of the city. Because the violation regarding the vehicle is, as of today, no longer a violation, I don't think I'm going to, I think all I'll do is recognize that it was cured prior to today's hearing.
Your Honor, the purpose of asking that you find them in violation but now in compliance is in case a vehicle would reappear again that's in a condition that's not repairable or inoperable, then it becomes a repeat violation. Under Florida law, a repeat violation, the fine would start, or a violation would be considered in occurrence at the time it's first observed.
Right.
That's why we like to do.
Okay, then I will find that I will find that at a prior date that it was in violation, but it was cured as of the date of this hearing. So, okay. All right. And I will allow 30 days from the entry of the order for the owner to cure the violation. Thereafter, there will be a $50 a day fine imposed, and I will also impose I will impose a fine to include the $120 of cost of prosecution of the case. And I would note, in looking at the tax collector's notice, it appears it talks about an escrow company on that on the tax collector page. So that indicates to me that maybe there is a mortgage on this property. So I'd like to, well, what I'm going to do on my order is include this address and send a copy of my order to this address that's on the tax collector notice. Unless we can find a better address from the public records somehow. So, just like I think it's good practice for us to let the mortgage company, if we can determine there is a mortgage company, to let them know what's going on the property. They may be just as interested in doing something to avoid liens piling up on the property. Okay. How many more cases do we have here? 3 more?
Four, but two of them should go fast.
Okay, well, let's, what I want to do is, I see some folks in the audience. I want to try to figure out who they're here for, unless you're here just to watch the proceedings, and take those cases first. So, those in the audience, are y'all here for a particular case? Yes. Okay. All the same case? No. Okay. So, which case are you here for, ma'am? Dexter. Dexter? Okay, and who's the... All right, and who's the other case? What was the last name? Larkin. Okay. So what,
That is next.
Case 3 and 4.
okay, so Larkin is next?
Mhm.
Then let's proceed with Larkin.
Okay, the next case is case number CE 2018-009, violation number 2018-07017, City of Newberry, Florida versus Patrina Latricia Larkin.
Okay, and who is here on, who's here that might give testimony on this case, the Larkin case? Okay, we just stand and raise your right hand so we can swear you in. Okay, thank you. Mr. Wolf, you may proceed.
Your Honor, I'm still Rick Wolf, Code Enforcement Officer with the City of Newberry, and I have been duly sworn. My credentials on file with the Magistrate Clerk. In case CEB 2018-009, the respondent is Patrina Latricia Larkin. The photographs that I will present into evidence accurately represent the violation as seen and were taken on the dates indicated on the photographs. On the 31st of July 2018, the City of Newberry Code Enforcement received a complaint of an unpermitted structure, a storage shed, located at 555 Northwest 252nd Street on tax parcel 022910000-000. The property was inspected by me on the 31st of July and was found to be within the incorporated city limits of the City of Newberry and in violation of the City of Newberry Code of Ordinances, Chapter 14, Building and Building Regulations, Article 2, Building Code, Division 3, Building Permits, and Section 14101, permits required. It shall be unlawful for any person to construct, alter, repair, remove, or demolish, or commence construction, alteration, repair, removal, or demolition of a building or structure in the city without first obtaining a formal permit from the building inspector. The property owner had installed a storage shed on the property without obtaining the required building permit. The property is zoned commercial, central business district, C-CBD. It's approximately 0.33 acres in size, and the property is homesteaded. A notice of violation number 2018-07017 was mailed by certified mail on August 21st to the owner of record as recorded in the tax collector's office, and this notice was returned unclaimed. Legal service was then accomplished by posting the notice of violation, the notice of hearing, and the statement of request for hearing on September 18th, 2018. And again, it was also posted in the bulletin board of City Hall. Here's some photographs of the property. This was my first visit on July 31st. And you can see the storage building to the rear of the house. On September 18th, by the front door, I did post the notice of violation and notice of hearing. And it was also posted in the bulletin board of City Hall. The property in question is a triangular piece of property off of 5th Avenue and 252nd Street, somewhat of an odd-shaped lot. And looking closer, this photograph from Google Imagery was taken on March 23rd, 2018, and the storage building was not there at this time, so it was placed in recent time. This was the photograph that I took yesterday. In addition to taking the photographs, I also did a search of the building department records to determine whether a permit had indeed been issued. We were aware that Ms. Larkin did come in once she became aware of the violation. She got with the company that she purchased this for and got some information from them, and she has applied for and received the building permit. Here is a copy of the building permit, number 2018-0381, and it has been issued. So we recommend a finding of in violation but now in compliance for the respondent, Patricia Lucretia Larkin. for the violation of Chapter 14, improvement of property without a building permit. That the respondent be issued an affidavit of compliance after hearing with no fine, and that further that the county not require any prosecution costs. So essentially, we're asking for a in violation but now in compliance and no further action. That concludes staff's comments.
Okay.
And we
Ma'am?
thank Ms. Larkin for getting her building permit.
Ms. Larkin, you've heard the city's position. Do you have anything to say based on that?
No, sir.
Okay. I'm going to, my decision will be to follow the city's recommendation to find that there was a violation for no permit, but it is now in compliance. No fines, no cost, and that'll take care of that case. And thank you for bringing it in compliance. I have a question on this.
Yes.
And I think we've had one other no permit code violation. In my mind, and I might be getting a little off track here, but in my mind, the contractor is also responsible for getting a building permit, right?
Not necessarily. In this particular case, the company that it was purchased from, I think it's called the Shed Store, or the Shed Shop.
Uh-huh.
They have right in their contracts and in their invoices, it says that property owner shall be responsible for obtaining
Right.
any permits that are required.
Um,
And basically, it's because that this is a move-on building. It's not really anything other, they're just selling the product.
I understand. Okay. I would just be, I'd like to know what the code says about
If a
that.
stick-built storage shed was
Yeah.
being built on the property,
Sure.
then the contractor would be as responsible as the property owner of record.
Because a lot of times, and the only reason I'm saying this is a lot of time, I mean, they're the ones that are in the business, and they should know that they need to go check about permits. Our owners don't necessarily know, something like that. So, and I'm not saying we would, that you would bring. I think that both maybe should be cited on situations like this. So.
Two things that we're doing to try to counteract that. One is we work very closely with the Department of Business and Professional Regulation
Right.
that issues contractor licensing. And if you do work without a permit and you're a licensed contractor, they can
Right.
put a hold on your license.
Right.
The other thing, we have from time to time contacted the storage facilities, the Storage Shed, Red Barn, and others, and given them handouts that explain what is required for what size shed, and to please pass this on to your
Sure.
potential clients.
Okay. Thanks.
Your Honor,
Yeah.
I'm just looking at the code provision, and this might not be the end of the analysis, but it is fairly broadly written. At 14-101, it says it should be unlawful for any person to construct, alter, repair, remove, or demolish, or to commence construction. So,
Right.
I don't know if there's further detail in the code, we can check on that.
Right. Okay.
Thank you. Good suggestion.
Okay. Our next case is Robinson, and that's y'all, right? Okay. Madam Clerk, if you would announce the next case.
Okay, and I'm assuming he's going to give me photographs for the record for that one?
For that particular case, I want to give the photographs for the record and a copy of the building permit showing that you.
Okay. Can we,
Great.
so the clerk.
Okay, so the next case is case number CE 2018-010, violation number 2018-07005, City of Newberry, Florida versus Dexter Robinson.
All right, and before you go, Mr. Wolf, is there anybody here on behalf of the Robinsons that might testify? Okay, if y'all would, anybody that might testify, stand and raise your right hand and be sworn in.
You want to state your name for the record? Sure. Swear to tell the truth, the whole truth, and nothing but the truth.
I am Rick Wolf, City of Newberry Code Enforcement Officer, and I have been duly sworn and my credentials are on file with the clerk. In case CE 2018-010, the respondent is Dexter Robinson. The photographs being presented into evidence accurately represent the violation as seen and were taken by me on the dates indicated on each photograph. On the 11th of July 2018, the City of Newberry officer, while on patrol, observed a single-family mobile home lot with an unlicensed and inoperative vehicle parked in the yard and with junk and debris, including trash, cans, auto parts, a refrigerator, and appliances, located at 751 Northwest 254th Street on tax parcel 02319-000-000. The property was inspected by me on July 11th, 2018, and was found to be in the incorporated city limits of the City of Newberry and in violation of Newberry Code of Ordinances. Specifically, Chapter 94, Article 5, Section 94-124, and this relates to wrecked or inoperable vehicles on private property. No person in charge of or control of any property within the city, whether an owner, tenant, occupant, leasee, or otherwise, shall allow any partially dismantled, non-operating vehicle or junked or discarded vehicle to remain on such property more than 72 hours, and no person shall leave any such vehicle on the property within the city for a longer time than 72 hours, except that this article shall not apply with regard to a vehicle in an enclosed building, vehicle on premises of a business operating in a lawful place and manner where necessary with the operation of business enterprise, or a vehicle in an appropriate storage place or depository. Also in violation of Appendix B Land Development Regulations, Article 4 Zoning Regulations, Section 4.2 Supplemental District Regulations with regard to parking and storage of certain vehicles. It prohibits in residential districts automotive vehicles or trailers or any type of without current license plates, and shall not be parked or stored other than within a completely enclosed building. And finally, Appendix B Land Development Regulations, Article 9 Minimum Housing Regulations, Section 9.24 Sanitation Requirements, and Section 9.24.4 is regard to care of premises. It shall be unlawful for the owner or occupant or of a residential building or structure or property to utilize the premises of such residential property for the open storage of any abandoned motor vehicle, icebox, refrigerator, stove, glass, building material, building rubbish, or similar items. It shall be the duty and responsibility of every such owner or occupant to keep the premises of such residential property clean and to remove from the premises all such abandoned items as listed above, including but not limited to weeds, dead trees, trash, garbage, etc. The property is zoned single-family mobile home, RSF MH-2, and is approximately 2.4 acres in size. The property is not homesteaded at this time, and the notice of violation 2018-07005 was mailed by certified mail on July 17th, 2018 to the owner of record and recorded on the tax collector's office, as recorded in the tax collector's office, and it was returned uncleaned. We did receive notice that the post office box may have changed by a relative, and we sent it to the other address, is where we attempted to send, I think, the notice of hearing. Because it came back unclaimed, we achieved notice of hearing on August 28th by posting the property and posting at City Hall. In that notice of violation, the respondents were given until the 29th day of August to correct the violation by completing one or more of the following actions: repair and provide current license tags for vehicles or removed from the property. Remove the refrigerator and all appliances, to clean up the cans, auto parts, junk, and debris, and remove them from the property. At this time, I'd like to show you the photographs. And this was my initial visit on July 11th, and you can see the one vehicle in the front yard. On the picture on the right, you can see a refrigerator in the front yard, and to the right of that, a trailer filled with dog crates and a couple of appliances. Closer view of the refrigerator, the cans in the trailer. And I believe at this time the refrigerator had the door on the roof. It's still installed. On the south side of the property, there is another pickup truck that appears to be inoperable at this time. Returned to the property on July 18th after letting them know that a violation existed, still the same condition. On July 31st, basically the same situation. I think at some point in time they did remove the door of the refrigerator. I think in the next photo, you see on the 31st, again, the cans, the trailer. In this photograph, August 15th, still the same scenario, the unlicensed vehicle, the appliances, the trailer, and the trash in the front yard. August the 21st, the refrigerator has been removed to the fenced area on the south side of the property. The vehicle is still there. They did do a little bit of trimming of the vegetation. On August 21st is when I did post the notice of violation on the front door, since the mail came back unclaimed. September 11th, the vehicle is still there. The appliance is still there. The truck is still there, and the trailer is still there. On September 18th, we posted notice of the request for hearing, and the notice of violation again, and the statement of violation and notice of hearing. It was also posted in the bulletin board at City Hall. At that time, when I went to the door to deliver the notice, see if anyone was there, no one was home, but I was able from the porch to see that, again, confirmed that this vehicle did not have a license plate. These photos were taken on September 25th, and at that time, the white Isuzu vehicle has been removed from the property. The trailer is still there, the cans were still there, and the pickup truck was still there. And just for clarity, not only does this trailer need to be licensed, but it can't be containing just a sundry junk on it, and it can't be stored in the front yard. So that concludes.
But that's the current condition.
This was taken yesterday. Yesterday.
So it's your testimony that the
violation still exists.
The trailer, the violation that's of the trailer being there, the violation of the second vehicle is still there. What happened? Is the refrigerator?
The refrigerator is now gone.
So that's
it's
in my mind, I've kind of narrowed it down to the trailer, two vehicles, and the refrigerator.
And now it's the trailer, one vehicle, and the trash, debris, and cans.
Okay.
And there has been some slow progress. I think the rest of this could easily be accomplished within 30 days. Again, we recommend removal of the appliances, clean up the cans and the auto parts and debris, and remove the truck and the trailer from the property, or get them licensed and operable and behind the front of the building. We recommend a finding in violation for the respondent, Dexter Robinson, for those three violations as stated in the notice of violation, and that he be given 30 days to comply as set forth in the corrective action stated in the original notice of violation, or a fine of $50 per day per violation be issued until compliance is achieved. And further, that the county recover the cost of $120 for prosecution costs. That
City.
includes staffs.
The city, right.
City, excuse me. That's an old habit that's hard to break after 27
I got it.
years.
So you're asking to allow 30 days to correct the violations and start a $50 a day fine after that point? Yes. Okay.
That's correct.
And the 120, and the standard 120. Okay? Is that all you have?
Yes, sir.
Want to present the photos and other items that will be admitted to evidence for the case? Okay, who wants to speak on behalf of the owner? All right, and before you start, would you state your name again for the record?
Dexter Robinson.
Dexter Robinson. So you are the owner of this
Mhm.
property? Okay. The first step that I do here is hear from you to determine if there is a violation, and then we talk about where to go from there. So you've heard the testimony of the code enforcement officer, or do you agree with the conclusion that this is in violation?
Well, we did move the stuff.
Mhm.
We tried to clean up what y'all say we can clean up. What we supposed to do?
Okay, and
So he should have that right there. We gonna clean up that. He should have other pictures of what we did.
uh-huh.
That right there, that been gone.
So this
This right here, if he ain't got no more other pictures, if he ride by and don't take no more pictures, how can he show y'all?
okay, now what I'm
Now,
understanding.
I can understand that right. Hold on. I can understand that right there. But we did make some progress to cleaning up.
Okay, but is this accurate as of yesterday?
Yes.
Yes. Have you done anything here since yesterday?
Yeah.
Yes.
Yes,
you
sir.
have. Okay.
Just got to move the truck,
But I have a tag on my truck. That's my truck.
Okay.
Me and my husband.
Step up so we can get you on the microphone. Okay. And state your name now.
My name is Geraldine Hoyt.
Again.
Geraldine Hoyt.
Okay. And okay, you heard the questions I've asked about is this accurate based on yesterday?
My truck is still there. I helped my brother and them, they moved the cans.
Right.
The trailer, Mr. Wolf said that we needed to push the trailer back, so the trailer is further back. And, the rest of it.
Right. The city has asked for me to find that there's a violation, and they've asked for me in the order to give another 30 days to get it taken care of. But you're both nodding your head, so are you in agreement with that?
Yes, sir.
Okay, and that will be suitable. Y'all are okay? Do you need more than 30 days to get that taken care of?
No, I don't need but 30 days.
Okay.
My truck,
Well,
my
well,
truck run, but I just want to get some more stuff there
Okay.
too.
So here's what I'm going to do, is I'm going to issue an order on this case. I'm going to find that there is a violation based on the photographs that were presented. I don't know what you've done since yesterday, but that really doesn't matter, because I'm going to give you 30 days from the day I enter the order, okay? And it's going to take me a few days to enter the order, so you're really going to have 30 plus a few more days to be able to get it done. What is the proper mailing address for me and the city to get mail to you?
P.O. Box 1004, Newberry. 10.
104.
No, 1004. 1004.
One,
I forgot it changed it. It changed.
1004?
Yeah, 1000.
1004, okay. And just so you understand, if you do, if if the code enforcement officer goes back out in 30 days and it is cured and this is taken care of, then there will be no fine applied to this, okay? The $120, yeah, okay, so there's an administrative fee of $120, so that would be applied, but no fine in addition to the 50. If y'all take care of it in that period of time, there would be no $50 a day fine. Now, if this is a point to say, if you don't, if it's not taken care of within that period of time, or a reasonable time after that, the code enforcement officer may take more pictures and bring it back to show that it has not been cured, and y'all will be called back in. At that point, y'all saw me do that at the first hearing today, where we actually put a fine on the property, and that won't be just a fine for you to pay. That'll be a fine and a lien against the property. So it could affect, your ability to sell the property or something like that. Just want you to understand, but there will be another hearing before that happens. Okay?
So what you saying, the trailer got to be moved?
To the backyard.
What I've been presented is the trailer, yes, needs to be, is in violation. Well, yes, you could get a tag, but still it's the stuff that's on the trailer too, so.
Oh, that's not on the trailer.
Okay, well, based on what I'm
Yes,
seeing
sir.
right now,
Yes, sir.
okay? And then the other junk and debris that's around the trailer just needs to be cleaned, and the truck needs to be removed. Yes?
Mr. Chair, perhaps I could clarify. The trailer, you could store a trailer in your rear yard if it's currently licensed and operable.
Right.
If it has a flat tire, if it has no license, or if it's filled with junk, you can't have it in the yard, period.
Right.
So if they want to keep it in the yard, just as storing the trailer without being filled with dog kennels and appliances and beer cans and that kind of thing,
Right.
they would have to get it licensed and the tires inflated and then store it in the backyard. It
Okay.
can't be on the side yard in front of the house. The truck, it can't have flat tires and the hood up. It's got to be licensed.
It's gotta be operable,
operable, roadworthy.
right?
And the cans can't be kept in a container in the front yard.
Right.
All the trash and debris, they need to completely clean up
Right.
of the
So,
front of the premise.
okay, and we're having this conversation right now here, and
Where you
I'm,
see
I'm,
my hood up at?
yeah,
I just use that as an example.
Oh, okay.
I'm,
I'm gonna say, you see my hood up, somebody be in my truck.
I'm going to enter the order as I just described. You will get a copy of the order by mail. Just as you've just had a discussion with Mr. Wolf now about what he's looking to have done, if you have any questions, you're welcome. You're perfectly fine to have that discussion with him. Have him come to the property and have that discussion so you understand what's going on. Okay?
Yes, sir.
You got it.
Okay, thank you.
Thank you.
I did give you the photograph in the case, right?
And the next case is case number CE 2018-011, violation 2018-02011, City of Newberry, Florida versus Bradshaw and Bradshaw.
Mr. Chairman, my name is Rick Wolf. I'm a code enforcement officer with the City of Newberry. And my credentials are on file with the clerk. In case CE 2018-011, the respondents, Bradshaw and Bradshaw, the photographs I'm about to present accurately represent the violation as seen and were taken by me on the dates indicated on the photographs. On February 20th, 2018, the City of Newberry Code Enforcement Officer received a citizen complaint about an abandoned, dilapidated mobile home creating a hazard located at 104 Northwest 251st Street on tax parcel 02133-000-000. The property was inspected by me on the 20th of February and was found to be within the incorporated city limits of the City of Newberry and in violation of the City of Newberry Code of Ordinances. Chapter 14, Article 6, Section 14.331 through 341, and specifically Section 14.334, creating, keeping, maintaining, or allowing the existence of dangerous buildings or hazardous lands unlawful. It shall be unlawful for any owner or real property owner within the city to create, keep, maintain, or allow the existence of a dangerous building or hazardous land as defined in this article or in such real property. The mobile home on this property was damaged, dilapidated, and structurally unsafe to the extent that it was dangerous to life, safety, and the general welfare of the occupants of people living in the city. The structure appeared to be vacant and abandoned and untended and unkept to the extent that it posed a health and safety hazard. The mobile home was at that time unsecure. There was windows open and places boarded. The notice of violation 2018-02011 was mailed by certified mail on February 20th to the owner of record, as shown in the tax collector's office. It was received by Dolores Bradshaw on February 23rd, 2013, serviced by registered mail. The legal service of the notice of hearing was obtained on September 18th also by certified mail, also signed by Dolores Bradshaw. In this notice, the respondents were given until the 24th of April to correct the violation by completing one or more of the following actions. Dangerous buildings shall be made safe by repair or restoration or be demolished and removed. There was several contacts made by Mr. Bradshaw. He advised that he was trying to save up and earn enough money to complete the corrective action, kept in contact with me, and told me where he was in trying to get his financial issues in order so he could take care of this violation. The photographs, this shows the mobile home itself, and you can see the windows that are boarded up, some windows open, no skirt around the mobile home, and in extremely poor condition. Branches on the roof. There's no power to the mobile home. As you can see, the power pole and the meter there has been disconnected. This was photographs taken on February 20th. On the 20th, the building official and I decided to condemn this building as unfit for human habitancy because of its condition. This was my visit on July 31st. It was still there. And as I mentioned, Mr. Bradshaw was keeping in contact with me. I gave him some suggestions as potential demolition contractors that he might want to get estimates from, and he did that. On September, third week of September, they commenced demolition of the structure. This was photographs I took on the 25th of September. And when they were moving the aluminum, and then they dismantled the walls, as seen on October 3rd. And on October 9th, the structure was completely removed from the slab. They had a little bit of cleanup to do, and I'm happy to report that as of October 16th, 2018, Mr. Bradshaw is now in compliance. We wish to find a finding of in violation for the respondent, Bradshaw and Bradshaw, for that section 14.334, and recommend that he be found guilty or be found in violation but now in compliance with no fine and no prosecution cost.
No prosecution cost.
That's correct.
I want to make sure I understood for the last case, you did want prosecution. I wrote down we do
Yes,
have
sir.
prosecution costs on that last case.
Yes, sir.
Okay. Okay. That will be my finding based on the evidence submitted. Is this a good address?
Yes, it
We
is.
think-
We've gotten response
Okay.
signatures every time.
Do you have photos or anything for this case you want to put in the record?
Yes, I do, just to document, and it's just hard copies of those photos. Mr. Bradshaw did call me and tell me he was unable to
Attend.
attend today, but I did advise him that we would be recommending no fine, no prosecution.
Okay. Is that all of the cases, Mr.?
That concludes all the cases from staff.
Okay, any other matters for this agenda?
I do not have any.
Okay, then we will adjourn. It is 2:11 p.m.
Thank you.